5 seconds to go. Start. The petitioner was apparently President, Consumer Finance of Religare Finvest Limited, a subsidiary of REL and a related entity from 15th May 2008. He was CEO from 2009 and Managing Director and CEO till November 2017. Mr. Singh submitted that he was at the helm of affairs of Religare Finvest Limited, subsidiary of REL, during the period when funds were diverted from REL and Religare Finvest Limited and other related entities. The petitioner, along with 12 other entities, had been issued common show cause notice dated 17th November 2020, along with relevant documents relied upon by SEBI for issuance of the show cause notice. The petitioner was required to show cause why an inquiry should not be held against him. After considering the cause shown, the adjudicating officer might issue notice under Rule 4.3, fixing a date for appearance of the noticee either personally or through a lawyer or authorized representative. Mr. Singh submitted that having filed preliminary reply, the petitioner repeatedly sought and obtained inspection of various records and documents. In addition to physical inspection, SEBI provided a compact disk containing voluminous records of most of the documents except some documents which were internal or confidential or affected the confidentiality of third parties and hence could not be provided. Mr. Singh submitted that the petitioner did not submit his reply to the show cause notice but sent emails demanding to know which documents were relied upon by SEBI and which documents were not. Further, online inspection was granted as physical inspection was not possible due to the pandemic. The petitioner made an application for supply of the following documents. According to Mr. Singh, the petitioner had been provided with all documents relied upon by SEBI which were relevant for the petitioner to reply to the show cause notice. Rules 3 and 4 of the Securities and Exchange Board of India Procedure for Holding Inquiry and Imposing Penalties by Adjudicating Officer Rules 1995 reads, whenever the board is of the opinion that there are grounds for adjudging under any of the provisions in Chapter 6A of the Act, it may appoint any of its officers not below the rank of Division Chief to be an adjudicating officer for holding an inquiry for the said purpose. In holding an inquiry for the purpose of adjudging under sections 15A whether any person has committed contraventions as specified in any of sections 15A, the adjudicating officer shall, in the first instance, issue a notice to such person requiring him to show cause within such period as may be specified in the notice, being not less than 14 days from the date of service thereof, why an inquiry should not be held against him. Every notice under sub rule 1 to any such person shall indicate the nature of offence alleged to have been committed by him. If, after considering the cause, if any, shown by such person, the adjudicating officer is of the opinion that an inquiry should be held, he shall issue a notice fixing a date for the appearance of that person either personally or through his lawyer or other authorized representative. Stop.